Case 2020G-019, Hicks versus Freeman et al. I have recused myself in the past and must continue to do so because of a conflict. I'll go ahead and transfer the gavel over to the vice chair. I'd like to have the record reflect that I've recused myself and not left the hearing room.
Mr. Executive Director, preference as how we proceed on these particular meeting motions.
Well, I have them for your benefit on the working agenda this morning. I put what I see as the motions to consider for everybody there. Mr. Bry's motion to dismiss due to complaints and proper contact. Mr. Bry's motion to dismiss for lack of personal knowledge or to limit the scope. Then the motion to quash for Ben Freeman. Then the motion to quash for Jane Hempton. Then the motion to quash for Gene Schmidt. That's the order in which I put them. I think that's what the commission should consider today. And you see listed on there my various recommendations as it relates to how they should be dealt with. Because I add any other comments that the commission may have.
Okay, let's proceed with number one, for a motion to dismiss due to the complaints and proper contact.
Did we want to limit presentations? Because I think everybody should have had all written materials circulated to them at this point.
I have a question about what motions are even being considered and being involved in the case and not being clear on what motions because I don't get feedback. I made a summary of all the motions that I'm aware of in this case, and I don't agree with them not being considered, or at least understanding why they are or not being considered. Is it okay if I hand out a list of here's the motions that are actually in the case?
I think Mr. Richter just indicated which motions are being considered today.
Well, I object to that certain motions are not being considered because I don't think your action at the prior meeting had anything to do with whether I'm allowed to cross-examine Alan Freeman on his sworn statement, for example, or whether, so I, as the complainant in this case, feel like I'm being put at a significant disadvantage both on discovery and not even knowing what's going to be allowed because motions have not been heard and they were not considered or decided in the last meeting.
I appreciate your objection, but if we don't have the materials placed before us to prepare for a hearing, then I don't think we as a commission are prepared to be able to make a ruling upon them. We have certain motions that were placed before us. We've reviewed all of them and we've prepared those materials, but if you're asking us to rule on motions that we've not specifically prepared for today, I don't think that's fair to the commission.
And I appreciate that. I don't think it's fair to me that I don't know, for example, whether I'll even be able to cross-examine Alan Freeman on a sworn affidavit. I don't know whether he'll have to take the stand to take the fifth or not. Because all that was decided in the last meeting was that filing of an affidavit didn't preclude you from, in a future hearing, the exact words of the motion, being able to assert your right against self-incrimination. So I just want to be on the record that I'm at a significant disadvantage, and this is some of the issue that's driven the communications, is that I don't even get feedback on what motions are being considered in a meeting. That's unjust to me as the complainant.
I would request that the commission follow the commission's agenda and not allow either party to interject on matters that are not considered.
Okay, we're going to just go forward with the agenda. You've put your objection on the record. We'll take note of that. So let's start with the motion to dismiss. Your motion.
Mr. Day, I don't think you had the ability, I don't think you were here last time, but what we did was we limited discussion as it related to each of the motions. And I think we had 10 minutes last time, but we've got 5 motions. I would say no more than 5. My recommendation would be no more than 5 minutes as to each motion, so we're not here all day. I know we've all reviewed the materials. Any discussion among commission members?
I'm gonna start with that if people want to hear more.
Okay.
Extend the time.
So be it.
Mr. Chairman, members of the commission, I'm Don Gryer here on behalf of respondents Alan Freeman and his campaign committee. There are 2 motions to dismiss that we have filed. The first one, which I'm going to exclusively argue now, is the motion to dismiss due to complainant's improper contact with commissioners. Mr. Hicks has repeatedly contacted members of the commission by email, arguing his position, arguing the merits of the case, expressing his dissatisfaction with the process, and disparaging counsel and counsel's client, as well as from time to time members of the commission and commission staff. we haven't included all of the emails. We attached 5 of them which were sent to every member of the commission prior to July 12, when Mr. Richter emailed Mr. Hicks and says, stop doing this. You know, the discussions with commission members of the merits of the case, going deep into that, and disparaging counts and so forth, could cause people to have to recuse themselves and affect things, so stop doing it. And after that, Mr. Hicks says, you're wrong, I'm not discussing anything, because an email is not a discussion, and I can keep doing it, and I'm going to. And on exhibits 8 and 7, on July 14 and 18, he sent emails to just 2 members of the commission. And on August 16 and 26, he then sent emails of the same tenor and tone, arguing the case, disparaging counsel and counsel's client to all members of the commission. And although it's not an exhibit, as recently as this past Tuesday, he sent an email to every member of the commission, once again arguing the merits of the case, arguing the merits of this motion, disparaging counsel, disparaging respondents in matters that are highly inappropriate. Respondents have a right, a constitutional right to a fair hearing. And the Ohio Elections Commission's rules require that kind of fair play. The members of the commission, according to the statute, shall not discuss a complaint before the commission or a panel of the commission with the party to the complaint. And I'm not faulting the commission. You didn't ask for the emails, they came to you. But the reality is that when you communicate through email, that is a discussion. We've all read written briefs, as discussed below, as discussed above. That's a discussion. And the rules of the commission say all papers must be filed with the commission staff, not directly sending papers to the commissioners. The rules of the commission say that pleadings and motions shall conform to the Ohio civil rules. Not directly sending a pleading, I suppose, in the form of an email directly to the commissioners. It's not even in the form that makes a motion or requires us to respond to anything. And it says that all parties shall observe the usual decorum as would be expected in a courtroom. Nobody in a courtroom is going to be, at least if they're a lawyer, and want to keep their license. You'll be sending emails directly to the jury, because you're the finding fact, or the judge, because you make rulings on that. That is not the usual decorum. And it's not like this is a surprise. Not only did Mr. Richter tell him in writing to stop doing it on July 12th, and he kept doing it, the commission's website has pretty clearly set forth how you do this and how you don't do this. His emails were also improper because they were ex parte. Now, ex parte isn't limited to emails that he didn't copy me on. He copied me on them. But there are some case laws that say that can still be ex parte, particularly whereas here, I could not respond to those emails without violating my duties as a lawyer, without violating the rules of the commission, but also without violating my duties as a lawyer. So it places, yeah, I know you had this email communication, but I can't say, no, this is right, no, that is wrong, as I could in real time if we had a conference, like we're having here with the commission, where we can go back and forth and express our views. They're also inappropriate because the disparaging opposing counsel and opposing party are not based on the evidence, is highly improper. We believe that Hicks' repeated unlawful communications with the commissioners would make any hearing unfair, and for that reason that the complaint should be dismissed. He did it on his own. He did it when he was told not to. You know, and you can't unring the bell. You've received this argument. You know, I understand, I don't blame any of the commissioners, but the reality is that this process has been so tainted by the misconduct of the complainant that it is impossible to have the rudiments of a fair hearing that is required. And secondly, what if you don't? What if you say, well, just don't do it again? You know, if the commission is not willing to enforce its rules of decorum, and maybe he didn't
30
understand.
seconds, Mr. Bryant, sorry.
If you don't punish bad behavior, you're going to get more of it.
Your response?
I'll start with the line he ended, if you don't punish bad behavior, you get more of it. So my email to communications, I have no regrets in them, because they are motivated, everyone, if you look at them, out of a continued issue here where, like now, I don't even know what motions we're going to consider. I don't know the basis. I'm not allowed to have the same kind of relationship on those things. It's completely unfair. You've seen it with the order, and one of the emails that I did was when the order's not being complied with. You've seen it when Mr. Bray sent a note to all of my witnesses telling them not, basically, don't work with him, he's an evil guy, to my witness list. That's one of the emails in there. So the issues with this body aren't me sending emails. I never sent an email to anybody until I think May 18th or something like that. And it was in result of, I had in writing from Mr. Ricker what motions were going to be heard in a hearing, and then he told me just they're not going to be heard. You know, this is a great example of this particular motion. I was not served this motion until the 21st. Okay, I pulled an all-nighter to write some response. I don't know if you even got the response, if you've had a chance to see and read my response. There was another case when I had a motion to compel earlier on in this, where Mr. Gray was given 30 days to respond to a motion. So at the beginning of mine, I put an objection on this whole motion that I haven't had time to respond. Now, this is not fair to me, and I have no regrets for communicating when constantly these things come up where I don't even know what motions are going to be heard. I'm told motions are going to be heard and then told they're not going to be heard. I don't know whether I can cross-examine Alan Freeman. Another thing that I had printed out on the list is the vast majority of the witness subpoenas haven't even been served.
I think
So-
we should limit ourselves to the scope of the first motion as opposed
Okay.
to all of the.
My point, I appreciate that, Mr. Norman. The reason why I'm bringing up these issues is that the core issue here is a constant lack of information to me that makes me concerned with the fairness of this process. Now, ultimately, for Mr. Bray's, did you guys get my response? Okay. So, I mean, I literally pulled an all-nighter to write it. He claims he sent it to me at an earlier date, and like on the 15th, which should still be a week to respond. I didn't get it till the 21st. And the funny part, excuse me of lying, is that you guys know me, I respond to all these things immediately, within a couple of days. So the notion that I intentionally lied about receiving something is completely false. I haven't had adequate time to prepare for this motion. I don't think it's right, because I looked at all of his cases. I went through and tried to examine all those cases, and I apologize for errors I made. I'm not a lawyer. There were 15 case citations. I always dig in deeper when lawyers put a lot of case citations and stuff, because usually they end up being off point. And there were ridiculous examples of malfeasance of a board, like a commissioner announcing their verdict and leaving in the middle of the hearing. A deadlocked vote, where then they removed a commissioner, put another commissioner on a board, and re-voted when the person hadn't even been in the hearing. A body that had no transcripts. Several cases that involved jury tampering, okay, where communications were secretly made with jurors, et cetera. I think a lot of the stuff was not on point. And his whole arguments about the statute and the rules don't hold up. He applies things about hearings to other communications. The reality is, I have not had a discussion or communication with any of you. Okay, there has been no interaction. One of those cases was the Patco airline strike, where the board members were having dinner with people that were involved in the case. You know, with one of his examples of this. When you get down to it, I don't think, in respect to Alan Freeman, that there's anything that has happened or that you guys have done, or has happened in this case, or any communications, that would imply that you or any of you towards Mr. Freeman have shown bias, partiality, or prejudice. I don't think there's been any example of that. If anything, this commission has bent over backwards. I've come here, you know, I like it better on Zoom, but I've come here countless times because there's always these motions, and we never get to the facts. And I always am left in the dark, and I'm getting, you know, I don't get time to respond.
30 seconds.
So I think that there's nothing in this case that would in any way imply that you're not capable of having a fair hearing and having a fair decision based on the facts. And one thing you notice in all his case citations, I think they all entirely, except the one about having a chain meeting of a public body, they all involve somebody appealing after the fact with an exact case for what was the bias that happened in the decision. I haven't seen anything from you guys that shows that you're unable to have a fair, unbiased hearing and make a decision based on the facts. I think the motion should be denied, or I should be given time to actually write a competent response versus an all-nighter, for which I apologize.
I guess my first question is, and I'm looking again, are you asking for a continuance to respond?
I'm asking you for either to deny the motion or give me a continuance to respond, yes.
You can't have your cake and eat it too. It's either we're going to make a decision today on the motion, or you're asking for
Then make a
continuance.
decision today based on what you know.
Now, I have a question for you, Mr. Hicks.
Yes, sir.
And I would agree with you that I don't think I'm biased based upon your correspondence with me, because I think what you were putting in your emails, I was seeing in your motions, so it doesn't affect me, doesn't change my opinion. But after you were told by Mr. Richter to stop corresponding with the commission members, why did you continue to do so? And if we have this continue in the future, what are we supposed to do with people who don't follow the rules?
I think if I'd have to look at when Phil's note was that
It
said
was in
that,
July.
which I objected to, by the way. I responded in,
I
now,
appreciate
but
your
let me,
objection.
I'm trying to answer your question, okay? If you look at the notes, they are continually, because of a lack of communication to me, a lack of clarity, a lack of follow-through on commitments that are made as to motions. You guys need to be aware of that. What am I supposed to do? If this was a court, and I was a lawyer, we'd be having a conference in chambers, we'd be having a sidebar, we'd be doing something. What recourse does a citizen have when things are not, when they're being treated very differently? Yeah, they have an email chain deciding what motions are allowed to be heard.
This just
I don't
reminds
get
me
to
of
make it be part of
reminds me
this.
of a parent and a child, where the child refuses to follow the parent's edict, which says, don't do this, and then we are the parent, what are we supposed to do? If you don't follow the rules and you're told not to correspond with commission members, and yet you continue to do it, what are we supposed to do?
Actually, in Mr. Richter's note, he said, I'm not saying that you're doing anything wrong. That's an exact quote out of his note. Okay? So just that you probably shouldn't do it, because if, and this is what was in his note, I'm paraphrasing, Mr. Richter can correct or read from the note, or I can find it. He said that if this continues, there could be more members that need to recuse themselves. So what I also put on my motion is, if any board member here feels that they are unable to make a fair and impartial decision based on the facts that they have bias, partiality, or prejudice, then they should do what Mr. Richter's note said. They should recuse themselves. This isn't a dismissal issue, this is a recusal issue, as was specified to me in his communication, that board members might need to recuse if they feel that they cannot be impartial. That's, you could read the note, that's what was exactly in the note from Mr. Richter.
Are you finished?
Yes, unless you like another way to do a question for him.
Any questions?
Commissioner Bailey?
Go ahead.
I'd like to say a couple things. One is, for Mr. Hicks, you cannot communicate directly with commission members. So just, I want to make that very clear. You cannot do that. That Mr. Fry uses the examples of what lawyers can and cannot do. Lawyers cannot do that. Pro se litigants cannot do that. You cannot do that. So if there's any question in your mind about what the executive director said to you, I want to make it very clear, you are to have no direct communications. And just because it's not an interactive one, doesn't mean that's not a communication. When you put us on your email, you can't do that. That's just, pro se litigants, some of us here are lawyers and involved in litigation, and they do get some leeway because they're not licensed lawyers, and we try to make sure that that happens. But they are held to the same laws and standards that everybody else is, including the lawyers. I think Mr. Fry is correct that he can't respond to that because ethically he knows he can't. We give you a little bit more discretion because, as you say, you're not a lawyer. You're trying to figure it out as you go. But if there's any lack of clarity in this, I'm going to be absolutely clear. You cannot have direct communications via email or otherwise with members of the commission. Now, that being said, when it comes to Mr. Fry's notion of somehow the commission members were unduly influenced or biased, I will tell you from my personal perspective, whenever I have any party before this commission email me directly, once I don't read them and I put them away, I have never read any, I read I think one way long ago, but after that I don't read them. And I also assign it to my junk mail, and so when I saw Mr. Fry's motion, I was actually surprised that we've been communicated with so many times because I wasn't even aware. In fact, I mentioned it to Phil. I'm like, we haven't been communicated with. He goes, oh yeah, you get all these emails. I'm like, well, I don't know that because I don't read them. And the reason I don't read them is why we're here today. because it really isn't fair for somebody to send us information that's not in a motion, that's not publicly available, even if you copy the other side, because they're prohibited from doing that. So I just want to make it very clear, I don't feel like I've been biased or prejudiced by it, but I'm a lawyer, so I sort of understand that this is the process and it's supposed to be followed. So from my perspective, I don't feel that it's unduly influenced me. I don't know about other members, they can speak for themselves, but I want to be very clear with you that you really can't do that.
Mr. Beatty, I also want to share that I'm not unduly influenced by any emails. I didn't read them. I'm, as I told myself, non-JD impaired individual. And so I know from common sense that you don't take into consideration that emails from parties that are before the commission. So I just want to reaffirm that I have not been influenced because I haven't read them.
I guess the only concern I have, and I don't have a concern that it's affected me, is the problem that it's continued. And what is our ability to do something? Because I know if this happened and I were a litigant in the court, the judge may take actions such as throwing the case out for failing to follow the rules. And I'm concerned, and then maybe this is directed to Mr. Ritter, what avenues do we have should this conduct continue as a commission?
Well, I think the only avenue that we would have is, kind of as Mr. Hicks has indicated, and I indicated in my original email, is, were you to feel you were impacted by it, you would need to recuse yourself from consideration. That's where it would apply. When I originally saw this email, or saw the motion, I'm sorry, and then sent it out to everybody, I indicated at the time, unless anyone or all of you get back to me and said you were unduly impacted, otherwise I'd be recommending dismissal, because I can't know what each of your respective minds are as it relates to this, but knowing you as I have from having worked with you over the last 2 years, I didn't figure that you would be unduly impacted, but at the same point I wanted to protect you from this kind of contact, which the statutes, as you already indicated, prohibit you from being involved with. You're supposed to be here, be unbiased as it relates to all this kind of stuff. So my recommendation is certainly to dismiss, or I'm sorry, to deny the motion, because I don't believe so. And some of you already said it, and I know Mr. Brown, you contacted me back and indicated that was the case for you as well. So I think denial is appropriate at this point.
I just think for precedent going forward, and this is the first time I've experienced this in the 5 years I've been on the commission, but if somebody doesn't comply, I think maybe the potential should be that there are recusals, and then you can't meet a quorum because the people can't follow the rules. But again, this is the first time it's occurred to me in 5 years.
Well, and I'll just briefly add, over the 25 years that I've been doing this, I've only really had 1 or 2 members ever get back to me with comments that they had been contacted in some manner or form, and their indication to me at that point was that they told the person, no, we can't be contacting you aside from the meeting, and they referred that person to me. So it has been a rare occurrence, fortunately.
I guess I'll go on record as saying I've not been influenced by the emails either, just because I don't read them, and it's to my work email, which is for my work. So when I see that come through, obviously it's not part of what should be coming through my work email, so it's been disregarded.
And as Mr. Richter indicated when he mentioned my name, I likewise was not influenced by an unsolicited receipt of an email that I certainly never responded to, and nor would I ever believe that that constitutes a discussion. Again, for the record, I was not influenced by the receipt of that email.
Anyone else?
I move that we deny the motion.
Second.
We'll do a roll call.
Yes, please.
Okay. Ms. Cunningham?
Yes.
Mr. Bromer?
Yes.
That works. Ms. Kaufman?
Yes.
Mr. Lars?
Yes.
Mr. Norman?
Yes.
Vice Chair Baby?
Yes.
That motion passes seven, or, excuse me, that's right, 6 to 9.
And, good luck. Okay. We proceed to the next motion. The motion to dismiss for lack of personal knowledge or to limit. And that means limit the hearing to the items contained in the complaint. Clarification. And we will again abide by the 5-minute rule. Council, you're on.
Thank you, Mr. Chairman, members of the commission. Our second motion to dismiss is the alternative, and actually there are sort of three separate items that are addressed in there. First, to limit it to items not pled in the complaint, because obviously nothing that wasn't pled in the complaint factually was based on personal knowledge. Second, to dismiss the second complaint, the one dealing with Luke Householder, because the one dealing with Luke Householder fails to specify all the elements for a prima facie case of any violation based on personal knowledge. And third, a motion to dismiss the first complaint, the one dealing with the 6 invoices that were sent not to respondents but to somebody else, because once again we claim that they were not prima facie case based upon an affidavit of personal knowledge. Complaints have to be based on personal knowledge. It's a statutory requirement. This commission is a creature of statute. It's not a recommendation. It's a requirement. We don't have jurisdiction if you don't have an affidavit based on personal knowledge. And personal knowledge has been defined by the court to mean first-hand knowledge, not second-hand knowledge. Usually they're talking about personal knowledge in Rule 56 motions for summary judgment, a personal knowledge requirement of extraordinary writs filed with the Supreme Court. There hasn't been a lot of litigation about personal knowledge, although it's the same term, and therefore it has the same meaning when it comes to Ohio Elections Commission cases. Personal knowledge has been defined by the Franklin County Court of Appeals as knowledge of the truth in regard to a particular fact or allegation which is original, as it does not depend on information or hearsay. This, by the way, is not a magic words requirement. In other words, if you don't say what basis it is, you might still have personal knowledge if it is apparent and specifically demonstrated from the face of the complaint. For example, he says, I went to the Secretary of State's website and saw this campaign finance report. That's personal knowledge of the campaign finance report, even if he doesn't say it. Or that, on the other hand, if you don't have personal knowledge of something, saying, I think this happened, well, that's not personal knowledge. Thinking is not knowing. And when affidavits state a basis other than personal knowledge, you presume that it's not personal knowledge, and you should reject that complaint, or at least that portion of the complaint, if it does that. Now, the affidavit of complaint has to clearly set forth a specific basis, contain all affidavits, exhibits, and documents relied upon, and clearly set forth sufficient facts supported by affidavits constituting a violation, and set forth every specific allegation. The only allegations in the 2 complaints are about Luke Householder and about the 6 invoices sent to other people for broadcasting, for the benefit, presumably, of Alan Freeman, if the invoices say what they appear to. Having said that, that's it. That is what the hearing ought to be about. It shouldn't be about, let's find other facts that were not pled in the complaint, by personal knowledge or otherwise, that we can expand the hearing into a surprise. Today we're going to say you didn't file this other report, or you didn't file some other expenditure that he had no personal knowledge and claimed no personal knowledge of in his complaints. And that's why we would urge that you accept at least that portion of staff's recommendation, that we limit the complaint and not allow it to be kind of a free-for-all allegations you can come up with that were never pled. I suspect if we have a hearing, it will be a easier path if we limit it to what was pled, wholly apart from this constitutional and statutory requirement to do that. Secondly, the affidavit about Luke Householder. He believes that Luke Friedman or Alan Friedman's committee violated certain things. He states that he has personal knowledge. He actually saw Luke Householder in a hotel room. He saw Luke Householder, doing some work or showing up at campaign events for Alan Friedman. All right, that's personal knowledge. They actually saw it. He doesn't say he has any personal knowledge that Alan Freeman's campaign paid for him or somebody else paid for him as an in-kind to him. He speculates. Maybe it happened. But he claims nothing in his affidavit. He says, initially I heard rumors that Mr. Householder was staying in Claremont Hotel. And I went down there and looked for a vehicle with his plates, took a picture of it. I saw him staying at Days Inn, and I saw him at other campaign events. Okay. Now,
Excuse me, I'm sorry, I looked away from you've gone over your 5 minutes
Okay.
already. Resume or quickly finish.
The affidavit, it doesn't say personal knowledge of violation. Luke Householder, the affidavit regarding the 6 invoices that were not sent to Alan Freeman, they were sent to Strategic Media Placement, Political, NCC. There's no allegation of personal knowledge or otherwise with respect to 6 invoices as to what they are, who they are, whether the amounts are accurate, whether these are entirely for it. They say they're not entirely for the Freeman campaign. It doesn't say who they are for and what amount, or any evidence that Alan Freeman or his campaign ever knew about these expenditures, or whether they were expenditures, wholly apart from the fact that in Luke Householder, there are ways in which caucuses can spend money on people doing multiple campaigns and never have to report anything.
If you need it, you have
I
additional
don't think I
time.
won't need it. I think I could stick to 5 minutes.
Okay.
I think,
I certainly won't sit there and say, Mr. Hicks, in 5 minutes
right,
you're done.
Okay,
You
so
know,
I'll get to deeper quickly into this, but I just want to give an example of this constant. By the way, there was an order on July 21, 2021, because of Mr. Bray's constant trying to separate these, get the 2 affidavits, get one of them stopped. So the director issued an order saying this is one case, these things go together, and this is what we're proceeding with. Now, I would say that my affidavits point to, if you look at the rules for an affidavit, what was the personal knowledge, and then what was the crime that's alleged to be committed. So he sometimes conflates those 2 things with what I see, what did I find out, versus what's the crime. Ultimately, the allegation is about massive media spend that took place that was never reported, about resources that are working for a candidate that are never being reported anywhere. Like Luke Householder was not an ORP resource, he was a constant content resource, he was never reported in any campaign finance system. Just to give if you would go with Mr. Bray's logic, it would say there should never be any investigation into any thing that comes before the OEC, because if you didn't know everything on day 1, it cannot be considered. I want to use the 6 invoices as an example. I put forward 6 invoices specifically from the FCC database that were based on, I live in the district, I saw these commercials, I saw on his Facebook page him saying, did you see my commercial on TV? Then I investigate, because nothing's on his finance report, I find all these FCC invoices. As we all know, I came pretty close on the media side. I found $118,000 worth of invoices. I would say during the investigation, after we had the preliminary review, then Strategy and Media reported actually $138,000. They also had an affidavit saying that they had paid the invoices on behalf of the Freeman campaign. So then we found out that there was actually that's still been hidden from me in disclosure, a set of communications of an invoice of $290,000 to the campaign. One of the things that's I think very important is an affidavit's based on the facts that you know, that you saw personally, investigation up to that point. But then once it goes into that there's going to be a hearing, there's discovery. There's lots of things that come out of that. And Mr. Bray now wants to go back to, well, you can only talk about these 6 invoices because of, we found so much more stuff. On the case of the resources, I don't know what more I can do to confirm, you know, that Luke Householder was doing work for Alan Freeman, being paid, and never being reported anywhere. I mean, I staked out the hotel he was staying at. They have personal knowledge of that. So the bar that Mr. Bray would suggest is ridiculous, and I feel like a lot of this is also deja vu all over again, because a lot of these things are very similar to what we did at the last meeting with Gene Schmidt and Ron O'Brien around these things. So obviously I think the motion should be denied. I think it would be utterly inconsistent with just what happened with Gene Schmidt. The next thing that such a motion would be accepted. And I don't know what else a citizen can do to have personal knowledge other than what I have done. And I don't know by what standard you would have that, for example, if a police officer had an affidavit, and then in the investigation, it was found instead of, 2 kilos of cocaine, it was 10 kilos or something, that then it was like, well, you can't charge you can't do it, you incorporate any of that. So I think the motion should be not denied. I think a lot of it's deja vu all over again. And the last thing I will add, how am I doing on time?
You're fine.
Okay, last thing I'll add is, Mr. Bray likes to talk about surprises. Well, we already had to submit all of our exhibits on August 11th, so what would be a surprise? I put forward to Mr. Ricker that there could still be some additional things, but the exhibits have already been submitted. So what's going to be the surprise? So he's worried about some surprise. There's no surprise. It's all already been put before you in exhibits that were due under your order on August 11th. So I think the motion should be denied, and we should go forward. I yield back my time.
Well within Don's time.
Do we have a motion?
Anybody have any discussion first? Well, I'll move that we deny the motion to dismiss based upon personal knowledge. I mean, consistently, we as a commission have dealt with pro se litigants, and I think, at least on its face, we've got enough here where we can proceed. We've already made the decision to set it for hearing, so it doesn't change my mind. So I would move that we dismiss that portion of it.
Let me stop you for 1 second.
Yep.
Given that this was a motion in the alternative, do we need to create just separate motions, a separate motion for the portion of the limit, the scope?
Yeah, and I wasn't addressing that in my motion.
Okay.
Mine just dealt with just the motion to dismiss itself.
Okay.
Second.
We have a motion and a second.
Yes.
I will do a roll call if that's your preference. Mr. Browner?
Yes.
Ms. Kaufman?
Yes.
Ms. Cunningham?
Yes.
Ms. Tavares?
Yes.
Mr. Norman?
Yes.
Vice Chair Bailey?
Yes.
That motion passes 6-0. I got the number right there.
Okay, do we have a motion on the alternative portion of that particular motion as to limit?
I have a comment before I make a motion,
Okay.
which is if you file a lawsuit or you bring a claim such as you're doing for this commission, whatever you have pled, that is the most you can recover and that is the most you're able to pursue. So I think Mr. Bryan's motion, although if we were in a court, he wouldn't have to make a motion, I think it needs to be limited in my motion. I would move that we limit the hearing as to the allegations and the complaints.
Well, and I think in the spirit of Mr. Hicks' request and comment regarding understanding the scope of what's going to be addressed in the future, that motion helps accomplish that.
I'd like to hear Mr. Richter's opinion.
I would tend to agree with that. I think this commission is responsible for complaints that are brought to it and for it, and the allegations that are contained therein, and that is what we make a finding on. If through this process, Mr. Hicks has come into other information that may invoke other elements, even though they're similar, he has an ability to file another complaint based on that information that he has subsequently developed. At least least that would be the approach that I would take, and the approach that I would recommend.
So, just sort of, so I can understand from a legal perspective, your view is that the statute would require that you specifically plead all of the items in violation. If through discovery you discover more things than that, should you amend your complaint to comply with the evidence? Or you're saying if it wasn't pled in your original complaint, you're not barred by res judicata for anything that you discover in this case that you might use and you refile in another?
Because, at least to me, because that would be a different set of facts and circumstances, separate and distinct from what was originally pled in the complaint, yes.
And I think the civil rules call for either seeking leave to amend your complaint, or if you're not time barred, you can automatically file the amendment, but we've not had any amended complaints to bring additional allegations.
And I will inject that as a general rule, because we have dealt so rarely with amended complaints, I will generally recommend that somebody file a separate and distinct complaint, which depending on when it is filed, we could consolidate in potentially, if, depending on when it is filed, or we conduct a separate preliminary review and hearing based on the second complaint and the evidence that's included therein.
Even if the violation is basically it's the same, similar violation based on the same campaign report?
Yes, because it's a different set of, there are different facts and circumstances that would support it.
Yeah, okay, so I'm just, just as a,
Sure.
I'm just struggling a little bit with, if I file a complaint and I say you violated campaign finance law number 1, and here are 6 examples, but I didn't name all the examples and I discover more through discovery. From your perspective, the complaint is limited to the 6 I cited, and I either have to amend my complaint to add more, or I would not be barred by res judicata for things that I discovered in this case on the allegation I complained about, to file a second thing for a similar violation for additional items that could have been brought up in my first one based on the discovery that I got.
But because they were not brought up
In
in
my
the
complaint.
original complaint, they are new and distinct and separate allegations.
Okay, and I can't do a motion to conform to the evidence or to conform to discovery to keep it in one place? I mean, it seems like counterintuitive to me, I'm just saying.
I guess the problem I perceive with that is due process to the respondent.
Right.
Whoever, all of a sudden you're hearing and they're bringing up brand new allegations that you didn't know were coming in your face.
Understood.
And I think that's the purpose for saying you've got to limit to the allegations being raised in the complaints.
Right. I get that part. My concern is about the next step. Then at that point in time, are they barred from ever bringing those up again?
Hold on for a second until we exhaust comment on this, because.
My argument would be no, because it's not a matter that we had previously addressed.
But res judicata it means you did or should have, could have, and didn't. It doesn't mean just what you brought up. Res judicata will bar anything that was based on the same facts and circumstances that were also raised the first time. That's my understanding of it.
Okay,
But we're a statutory board, so maybe not.
well, that's
why I'm using it.
different than how we have ever operated
Okay.
in the past.
And I think there's also an issue of the discovery rule, knew or should have known. I mean, if you
Right.
don't know it, all of a sudden you discover it and you didn't have it before and couldn't have had it before, that would change whether you're barred from bringing that up again.
In the same or future litigation.
Correct.
Yeah. Okay. I'm just wondering.
Okay.
I mean, it's a very technical view, I think, but I get it too.
Right.
Mr. Hicks, your question or comment is on this particular issue?
Yes.
I suppose procedurally it would be Mr. Bride first, since it is his motion. Do you have anything further?
Well, I obviously support the motion. I think that one of the challenges we've had is knowing what it is we're arguing about. And keeping to the point, I think, is important for our due process. You know, yeah, there are a lot of exhibits, but, you know, who knows what actually, Mr. Hicks, or he may not know what I'm gonna say, don't understand. But whatever we say, I think legally is required by both the statutes and the rules of this commission, rules of process, to be limited to what was put.
Is your comment for this particular motion, or are you looking for guidance based on the way you see it's going?
I think it's the comment on the particular motion. I think they a little bit blend together. So, am I allowed to comment?
1 minute.
Okay. So I just want to think of the preposterous notion. I'm going to get to a point of that what we're talking about would create would be, for example, that I've said 6 invoices under $18,000 and then immediately found that SMP said they paid $138,000. But now that can't be included because, you know, just the preposterous nature of, it's not as if I introduced, my allegations were massive media spending that was not reported and resources that were not reported. My allegation wasn't 6 invoices. Okay, and the actual affidavit requires you to separately specify the facts and evidence you have and what is the actual allegation you're making. And so I think my allegations, I have not gone off the script of the allegations that were in those 2 affidavits of massive media spend and resources not reported. Now, the notion also that as a citizen, I would have to keep refiling additional motions, it's just ridiculous, especially if we can't do these meetings on Zoom, okay? Just the amount of effort it takes to do something. So I would say that either his motion should be denied, because we already have the exhibits, you know what I'm gonna talk about. So it's not, doesn't go off the point, it was already submitted, his motion should be denied. If it's not gonna be denied, then I would ask that there would be a continuance of the whole case so that I can amend my complaint, so that I can make the complaint conform, so that I don't have to go through another year-long process to get to the same point we are right now. But the notion, I think it's a very dangerous notion, the concept that somebody makes a specific allegation, like, for example, unreported media spend has specific evidence, and then an investigation uncovers the exact numbers for that, but you can't consider the exact numbers. That doesn't make any sense to me, I'm not a lawyer, but it seems like a preposterous outcome for how the election commission would work if that were the manner in which it worked. It would say, why even do discovery? You have to know everything up front. Why even do discovery? To pinpoint the numbers and the facts. So that's so I recommend the motion be dismissed, but otherwise I think that either the case should be continued so that I can amend my complaint, or this board should then, it's another serious issue like in the 5th, like pleading the 5th, is figure out, this is not a quick answer because it has long-term implications for the hearing of any complex case where evidence can come up during the investigation period that pinpoints numbers more accurately and what happened more accurately.
Okay, thank
Thank you.
Thank you very much.
May I respond to the motion he made as part of his remarks?
Well, I don't think we're gonna
Okay, fine.
let this gravitate toward outside of what we are dealing with, so. Is there a motion?
There was a motion placed to, to sustain the motion to limit to the elements in the complaint.
I'm gonna withdraw my motion, only because I think we need more discussion. When we're talking about a civil case, courts generally say leave shall be freely given to amend, to make sure all allegations can be heard and brought before the court. And if Mr. Hicks is asking for leave to amend his complaint because there's more that he feels needs to be addressed, I think we as a commission should consider that. Because as we know, he's limited to what is being pled, and that's what the motion was. But if he believes that he has more evidence and he has more that needs to be amended to include the pleadings, or in this case, his complaint, I would be a proponent to say allow him to do so.
Go ahead.
May I respond to that suggestion? A motion to amend in connection with the Ohio Elections Commission would permit him to create new allegations without a new preliminary hearing. In other words, we would still have to go through a preliminary hearing in order to determine whether or not those new allegations were proper. And it would not actually save any time, because we'd still have to be going through the same process. It would take the current pleadings and blow them up once again. This case has been going on for about a year. This is the fourth motions hearing we've had with the full commission, absent the recusal. It has cost my client a huge amount of money, and we would like to get this case done. I would respectfully suggest that continuing this case and allowing additional amendments, when after all, he can file a complaint if he wants to. And we'll deal with that, but he will then understand that when he files a complaint, he's limited to the facts of the complaint and can't do a bunch of discovery on things that aren't related to it or try things that aren't related to it. I would like to get this case done. It has been costly and prejudicial to my client in terms of time and energy, and to allow one more continuance so that something else can change entirely what this case is about would seriously prejudice my client, deny his due process rights to have this done in a timely manner.
If he files another complaint and files a motion to consolidate, doesn't that effectually do the exact same thing?
No, Your Honor, because if you file a motion to consolidate in 2 weeks, hopefully this case is going to be done. And we're going to have maybe in 2 weeks we'll have another preliminary hearing, but otherwise the whole thing is kicked down the road. I don't want to kick it down the road. Obviously I can't force the commission to do it, but I would question whether it's really in the interest of the commission to have these things drag on any further than this drag. If there's another complaint, we'll try to get that, we'll try to deal with that as we can, but at least we'll know what it is. And at least we'll have a clear target of what to respond to and what to allege in response to that. Because right now, we don't. And right now, giving a carte blanche to Mr. Hicks to amend it and not even, and continue this, who knows how long it'll be continued. Maybe we need more discovery on that. Maybe they need more discovery on that. But whatever happens, if we allow a continuance and amendment, we're not going to try the current case in 2 weeks, and we're not going to get done with it.
Am I able to respond?
Hold on. With that being said, would you want to withdraw your motion to limit?
I would not. I have a constitutional and statutory right to limit the case to what is in the complaint, and I have no intention of withdrawing it.
Am I responding? I think there's a little bit needs to be seen through. Mr. Bray wants to save his client money by having me file extra complaints, extra affidavits. It doesn't make any sense. The allegations in this have been very clear. Massive media spend, resources that weren't reported. I've never deviated from those allegations. I've never added other allegations. I've never put things. So the notion, this motion was filed on September 17th. September 17th. If this was an issue, why wasn't this motion filed months ago to do this? This is just a tactic because of the imminence of the hearing. And I think it's just a very dangerous path that you have can I finish my remarks now? I just want to have equal time as Mr. Bray when we're talking. So I'll take less, I'll try to take less. But the notion that, I keep bringing forward my allegation in the affidavit. I'm not a lawyer, so if there was something criminal that happened, you had affidavits from 7 people that saw different things happening, they would boil down to an allegation that would be investigated by the police and somebody would be charged. The notion, this probably is not accurate, but I want to me that would be kind of like saying, well, if there's something that came up in the investigation that shed light on something that was in the affidavit of different policemen, we can't consider that because it had to be. So I think the affidavit provides an allegation. It's statutorily required that, or your rules require that it has to have what's the personal knowledge and what's the specific allegation. The allegations were about massive media spend that wasn't reported and about resources not reported. I think I stuck completely to that. The irony of this is, since August 11th, you've all had my exhibits. He's had my exhibits. You know exactly what I'm going to talk about, exactly what I'm going to focus on. I think that if Mr. Bray wants to use this tactic to hamstring under the guise that he's going to save his client money by making me file additional things, I think it's fair for me, because those additional things would take time, and you know I will absolutely do it. So I think then either this should be denied, you already have the exhibits, there was already an order around this, to deny it, but otherwise, I want time, I don't want to have to do a whole different set of streams of cases and preliminary reviews, and you probably don't want to see me coming here doing cases and preliminary reviews. So it would certainly save us client time, energy, and money then to give me time to amend a complaint so that this can be properly and fully considered. And the net result is that it's going to just take more time. Either way, either I'm filing more affidavits, or I amend an affidavit. It's just adding to all this, and it's a day late and a dollar short. I think it should be denied, because for my allegations have never changed, and you've already had my exhibits for more than a month.
Well, I differ with you only in that, and I don't want to speak for Mr. Bry, but I'm guessing he filed his motion because he wanted to limit you so you don't continue to go off on the reservation on all of these different issues which don't pertain to what you have actually put in your complaints. If you are sitting here and you're honestly telling this commission you believe there are more allegations that you need to amend your complaint to actually bring in, then I would not be opposed to granting leave to amend. If you're looking to just extend this hearing and keep doing a bunch of stuff and going off the reservation, I'm telling you as a matter of law, you at this stage, I believe, are subject to only which appears in your complaints.
The allegations or the specific evidence I have?
The allegations, what you have raised as the violations in your complaints.
So the allegations in my complaint wasn't 6 invoices. The allegation in my complaint was that there was massive media spend that was not
I'm not looking for a
reported.
debate. I'm asking you, do you believe you need to raise additional allegations in an additional complaint, or are you comfortable living with the allegations you have raised in the complaint you have filed?
If the allegations, you're confused.
You're not answering my question. You're
Because
giving
I'm
me a
confused on the
gift
question.
reply.
Can I ask for clarification on the question?
You have filed 2 complaints,
So
and what you have set forth in those complaints are what we as a commission are going to hear. That's it.
but his definition of that is 6 invoices. My definition of that is massive media spend that was not reported. That's why I'm confused by you asking your question in that way. So the definition that I think is that my allegation was massive media spend that was not reported. My allegation was resources that were being used that were not reported. That was my allegation. I offered evidence. You get into the circular reference. Was I supposed to offer evidence I didn't have that then he would say wasn't personal knowledge that I put in an affidavit?
So we cannot provide legal counsel to you. What you need to do is
You can't ask a clear question.
hire counsel to assist you, or know that if you proceed forward, I'm going to make a motion that you're limited to what is listed as the allegations in your complaints.
The allegations are just 6 invoices. What does it mean?
I'm not here to provide counsel to you. I'm telling you what we as a commission are capable of doing.
And I would ask, maybe you should all pause and read your own mission. The notion that you won't answer a question is, does your motion mean the 6 invoices only, or the allegation of massive media spend? And to tell me I should go hire a lawyer to get an answer to that question, I think defeats the purpose of this being a body that's supposed to be making it easy to get resolution, proper and fair resolution on campaign finance issues.
We're here to make decisions. We're not here to provide advice to you.
Can somebody
But your
answer?
simple question is, what is the definition of an allegation
Right.
in this particular?
6 invoices or
Is that-
massive media
No,
spend?
no, not the fact. I'm just saying, you're asking, is an allegation the claim of wrongdoing generally, as in the statute? Or is it allegation means a specific subset of facts? Is that the question that you're asking? I'm
Correct.
using your
And I
example.
pointed out that your own rules say that an affidavit has to have what was your personal knowledge, and then what is your allegation? And what code sections did you believe were violated that supported by your evidence? Then when you do a preliminary review, there's discovery and investigation. And if we were to go down this path, if things came out in discovery and investigation, like that the actual amount was $138,000, not $118,000, the logic would be that the complainant has to refile something, or has to amend something, or has to do something. I was unaware of this has only come up since September 17th, when he filed this motion, okay? This part about limiting. It's already come up a couple times when you had the order, when he was trying to get behind the scenes, get rid of certain important things, and Mr. Richter issued an order. So, you know, the key thing here for me is that definition of what's the allegation, and I know I'm seeming like a broken record, and I apologize, but I've never gone off the script of the two things that were my actual allegations. Right, what's happened is more evidence has come to light in discovery, like that it was, like that strategic media said it was 138, not 118.
Then I believe you answered your own question. What is an allegation, what is evidence? I mean, as a layperson. So if, you know, Mr. Norman is directing you to kind of investigate what an allegation truly means, and Mr. You know, Vice Chair Beatty is as well, I think that that's the answer. So we can belabor it for an hour or more, or we can, you
Well,
know.
I just want to make a quick comment. I apologize, but, you know, he's got a lot of words in his thing, so when you're making motions and agreeing to something, I'm very careful about what might be in something that he wrote in something that was submitted on the 17th, that may create an implication that's not maybe the intent of this commission as to what it means. So I think you need to be specific, because he's made representations in his filing as to what these things mean. And a vote that to accept that might be applied is meaning whatever he said in his thing is true, accurate, fair, and correct.
May I just respond briefly? This is a quasi-civil, quasi-criminal proceeding, and therefore respondent, who is potentially charged with criminal conduct, has a right to know not just the statute, but the factual basis for that. The rules of this commission require that, as well as the statute, that there be a prima facie case, which is facts, that support an allegation of the statutory violation. In a criminal case, if I were accused of breaking into Mr. Smith's house, and they found in the course of their investigation, they also broke into Mr. Jones's house, they would not be able to present evidence and convict me of breaking into Mr. Jones's house at the criminal trial in which the criminal complaint accused me of breaking into Mr. Smith's house. And it would violate all kinds of due process to require me to do that as someone who is potentially facing, you know, criminal referral. I don't think that the amendment process, I think the reason the amendment process has not been used often in the Ohio Elections Commission is because it's inconsistent with the rules of proceeding in the Elections Commission, unless both sides agree to that, which we're not here. Because the rules of this commission require that you make a new allegation of new factual basis for a violation, that you have a new proceeding. You might be able to consolidate them if the timing works out for that. And by the way, if he does make new allegations, new complaints, you know, we would have an opportunity to try to knock them out and to defend against them at a preliminary review. And you know, frankly, we're more than willing to take our chances on doing that. But that's not going to happen if he somehow is able to avoid the procedural requirements of a new allegation by amending it or in the guise of amending it, avert the need to present that factual argument in front of the board before anything else happens.
Potentially that, though, raises if they're not consolidated, you have two hearings with the same set of facts, the same set of witnesses, and this commission is, instead of consolidating, having basically to serve the jury on two separate occasions with different commissioners. Because at the end of the year, you're going to have three commissioners who are leaving this commission. And so it seems to me that either you file your complaint, consolidate, or you amend, it's the same result. I think just hearing, if Mr. Hicks actually intends on filing an additional complaint or seeking leave to amend, it should be granted so that you're not getting inconsistent results with different commissions.
I have a 30-second response to that. So he gave the example of Mr. Smith's house and Mr. Jones' house. Great example, I love it. If I broke into Mr. Smith's house and stole a bunch of stuff, and then Mr. Smith reported in an affidavit to the police, these are the things that were taken out of my house, and then later it was found, oh, the guy who robbed your house also had a diamond ring. Oh yeah, that was my diamond ring, I didn't list it in my affidavit. I don't know the answer to the question, would it say like, well, we can't do anything about that. He gets to keep the diamond ring. We're not talking about unrelated things. We're talking about a very straightforward allegation of media spend, all involving the same people, S&P, Alan Freeman, et cetera. The other thing is he said, prima facie case. So I don't know what that meant exactly. I know what it means generally, but so last time we were here, he was arguing about an affidavit needing to show just probable cause. So the different use of definitions, obviously my affidavit showed probable cause in a preliminary review phase, and then there was discovery and an investigation, and then that just shed light on the exact allegations that were in there, like that it was 138,000 versus 118,000. The idea that that requires different complaints, consolidated complaints, that you always have to amend if you find something, would make, look at how this case has worked. It would make things here take decades to get anything done. And so I think the right answer is just to deny the motion, and then, but like I said, if you're not gonna deny it, then I wanna have the opportunity to consolidate, so I don't have to go through everything all over again for a year, that I'd rather take more time and get it all consolidated now. But I think the right answer is to deny the motion.
Okay, hold on.
Go ahead, Arnold. I'm sorry, I didn't mean to interrupt.
No, go ahead.
I think you need to reflect on what you're saying, Mr. Hicks, because if you're saying we should deny the motion, I think as a matter of law, you are bound by what is in your complaints. And so if you want to proceed with what's in your complaints, that's your choice. If you feel there's more that needs to be added to your complaints, then you either need to seek leave to amend or tell this commission that you'd like a continuance because you're going to file an additional complaint and you're going to ask to consolidate.
I think this is our confusion on, my allegation was massive media spend. I
I'm not asking for any more rhetoric.
presented information to gain probable cause. Then there was discovery and investigation. We found things like that instead of 118,000 as 138,000. The notion that that requires all this extra work would make this commission unable to function.
Okay.
Well, we functioned for years.
I think these kind of cases, you're probably good with these, the LaRose referrals and stuff like that. I've said before, this is a canary in a coal mine of more complex cases where these factors come into play. And I think that for the state of Ohio, and given the issues that have happened in campaign finance, beyond this case, this commission needs to figure out how it's going to deal with those kind of things, because we desperately need a commission that can deal with these kind of more complex cases.
Mr. Hicks, it's pretty simple here as we sit here looking at you. You either need to say, I'm prepared to proceed with my complaint as it's prepared, or I'm asking to amend, or I'm going to file an additional complaint. That's the only issue facing you right now. I don't want to hear any more argument about what else is the facts and the change in money. What do you want to do? What do you intend to do?
Okay. I am prepared to proceed with the exhibits in the case that I have already had to submit on August 11th by order of this commission. I have had no objection from him or anybody else about what I submitted for that, and so that's what I'm prepared to proceed with.
That was not one of the two things I think that Commissioner Norman said. And clearly, Mr. Bright is objecting to those because he has a motion today to limit you to a complaint and the 7 invoices attached to that. That's what's before that commission, 6. If we grant his motion, you're limited to a complaint and 6 invoices.
Well, he just said if
If
you
we
deny the
grant-
motion, then I'm limited to that. So I'm being as simple as I can. I'm not a lawyer, I'm a lay person. I think this commission needs to give latitude, but it needs to work. It needs to work for, you need to look at what the mission says for this.
So,
board.
okay, stop. The latitude we're giving you is this, 2 choices. 1, we'll rule on the motion, and if we grant it, you're limited to the complaint and 6 invoices. If we grant his motion.
Okay,
Or Mr. Norman is saying, if you're saying, that's not what I want, you can make a motion to continue the case and leave to amend or to file an additional complaint.
if you deny his motion, so you said if you grant
No.
his motion.
No, this is not a debate, I'm telling you. His motion is to limit the hearing to the items specified in the complaint. If we grant that motion,
Yeah.
you are limited to the items specified in the complaint and 6 invoices.
I think you should deny that motion.
Okay, if we deny the motion, Commissioner Norman is saying, you're gonna be limited to what's in the complaint.
So you're just saying it's the same thing, deny and
That's
accept,
what he
it's the
thinks
same
the
thing.
law says.
Okay.
Let me tell you, Mr. Hicks, that is a motion I would put forward before this commission if you are not seeking a continuance or a motion to amend. I just need an answer because I'm ready to put forth my
What you're
motion.
saying, so I just want to be clear, no matter whether you deny or don't the motion, what I've just had explained to me.
You haven't heard
it's
his
the same
motion yet.
result. So I think, I do whatever you want. I think Ohio needs to see how this commission is gonna work. And the notion, for example, that I've said it again and again, my allegations were very simple. Massive media spend that wasn't reported and resources that weren't reported on any campaign finance report. I presented probable cause in an affidavit and a preliminary review. I provided evidence and I made those specific allegations. In the discovery period, we discovered that the number, for example, was 138, not 118. Somehow that's some complex thing that we have to, that either I have to amend, I have to do this, I have to do that. Do whatever you want. I feel that the case should proceed with with the allegations, which is massive media spend and resources not reported, and the evidence that is obtained during discovery and investigation. The notion that that needs to create a new case or a case consolidation to me would be an absurdity.
That's the law. And I'm giving you the chance to unring the bell before I ring the bell and say,
Do whatever you want, Mr. Norman.
I'm giving the opportunity, and I'm gonna put it here on the record, I'm giving the opportunity to ask this commission for the opportunity to amend my complaint or file an additional complaint should I think there are allegations. If not, I'm prepared to proceed with a motion.
Well, I would wish to be able to file additional complaints. So we keep adding extra little things.
That's already been discussed earlier in the very beginning.
So would your action on this
Director-
motion have any impact on my ability to file additional complaints?
No, and that's what the executive director explained in the back and forth among the commission about how this could potentially play out.
So in theory, just a point of
Well,
clarification, I
it's
could
really
withdraw my
began-
complaint and file a whole new complaint
You could.
Yes.
after you make whatever decision you have here. I just think you guys need to talk without us talking about the what's the intent of how this, you look at your mission and the idea of what you're supposed to do. It's just to figure out how you want this to work going forward, because I think the notion that 118 versus 138 is my great example, that this requires this kind of discussion for this long is a point of absurdity.
Just one point, I fully support his suggestion that he withdraw his complaint.
You know when's coming back, so that you're interested in saving your client money supposedly.
What, can I ask you a question as a layperson? What is the difference between withdrawing and then submitting a new or amending? So if he amends, is that maybe not as laborious,
Same process.
same process?
It would essentially be the same process, yeah.
Okay.
I mean, we would still have to, the commission would still have to take it up under preliminary review and assess the elements of those complaints.
But you would
Nothing has
have-
to be withdrawn.
But you would have the discovery,
Presumably complete.
complete in the case. Versus, there's always an issue if you have discovered in one case, how that would translate to a new case, and if there are new allegations. It could get bigger, it could get smaller. So those are,
But we have knowledge. If you amend, then at least we have the basis of the complaint, and we're just adding whatever has been discovered in the meantime.
that's one, yeah,
Okay,
That
I mean,
could be
very,
the
very
case.
much a layperson's
Yeah,
take on it.
that could be the case.
Okay.
Or it could be an additional complaint.
Right.
And if it's not consolidated, then you're talking about having the same witnesses, the same set of facts, and everything decided by a completely different set of the commission.
And possibly all discovery all over again.
Well, judges lose elections and
They move on.
and cases will go on, so.
You're also, very quickly, you're setting a precedent that says, expect a lot more complaints. Because anytime somebody finds something that it was 138 versus 118, new complaint. So it's.
Mr.
the
Hicks, we
unintended
understand your arguments. At this
Okay.
point, it's before the
Right.
commission.
Okay.
We're not taking any more arguments at council. I hate to cut you off, but we're not advancing the ball here. We're flogging a dead horse, so let's just move on.
Mr. Hicks keeps bringing up about the difference in the amounts. If you look at the motion, it says motion to limit the hearing to items contained in the complaint. We know what items are in his complaint. If he should find before we go to hearing, full hearing, that he has new information, but it's within those items, we're saying he can't bring it up if we pass this motion.
Right.
And that's called due process to the respondent,
Right.
who is now facing a quasi-criminal
Right, he's entitled to know what he's being charged with, basically.
You're not entitled to show up with surprises.
Right, so
Okay.
if you're accused of something, you are entitled to know specifically what you're accused of
For that complaint.
from that complaint.
Absolutely.
That doesn't mean that if things come up, you can amend or file anew or whatever. But, yeah,
And that's not, this is the law. This is how this commission functions, that's how the law
well, that's
is.
why I looked to Mr. Richter about
Yeah.
the history of the commission, how it's functioned. And Mr. Richter, can you weigh in? Do you have any other insight at this point?
I mean, I don't know if this case is any more complex than any other case the commission has ever had. There are campaign finance allegations, and there's, this has either been established or not. And so I don't see this as being any more complex than any other matter that the commission has handled. And, there are, the facts will be brought forth, to me at least. The complaint says what it says. It does allege that there are violations of, 13B and D about keeping an account of all contributions and expenditures. That's those receipts are the elements of the basic elements of the complaint. There's other information that might be beneficial to the commission to help it make a decision. I see those as being something that could be submitted to the commission as establishing, whether it's been a violation or not. That's the way I view this coming forward. I don't think I'm wrong, or I don't think that I'm stepping on somebody's due process in terms of how this goes forward. But the allegations that have been presented is that there have been problems, let's put it that way, with campaign finance reporting, and if we get evidence that establishes that, then we make a decision that says that's the case. If there is not sufficient evidence to go beyond what is alleged in the complaint, then we find no violation based on what evidence is presented to the commission. That's my view of how this thing should go forward. And so I guess I look at it as when we're limiting what's in the complaint. What's in the complaint, Commissioner Alan Freeman failed to account for media expenditures on his campaign finance statements in violation of 351713B and 10D2. That's what the commission has before it.
Not specific amounts and not specific invoices.
I mean, there are specific amounts included in certain elements in here, yes. But to me, that's what the commission is assessing. And I appreciate what Mr. Bry says about believe as opposed to personal knowledge, et cetera, saying I believe that Mr. Freeman failed to account. But with all of the other elements involved in this complaint, research of the records, et cetera, brought forward, we have certain elements of the complaint brought to us in terms of here are media amounts that are out there that supposedly have been established for this campaign. And there were only supposedly so many expenditures made. There's a discrepancy there. Can that discrepancy be established in the evidence that's presented to the commission? Or not?
There was also, this other affidavit had a slightly different allegation, because there were two affidavits.
I appreciate that. I was only talking about
I know,
that, but that's what I was talking about.
So I guess, there's a noticeable lack of conversation here. That last issue I raised about if additional information should come into Mr. Hicks's personage, if you will, that has a direct nexus to his initial and original items. We're saying by this motion, he's limited to bringing that information up, but he has an avenue to file a new complaint
Correct.
on that new information. Do we all agree with that?
I would agree with that, although if I were sitting in Mr. Bry's chair, and again, I don't want to speak for Mr. Bry, if new allegations were brought forth, I'm sure there will be a motion to dismiss based on res judicata saying, if you knew or should have known this, you should have brought it the first time, and you did not. And therefore, you're precluded from bringing that before this commission.
And that might be the eventual outcome, but Mr. Hicks still has a right to pursue a new allegation.
Anybody can file a complaint.
Then I would think, Mr. Co-Chair, we've exhausted this, and I think it's time for the commission to make a decision on Mr. Bry's motion.
Is there a motion? Because I thought Mr. Norman drew.
He withdrew his motion.
Right,
There was
so
no
we
motion
rolled
currently
it.
pending on the floor.
I
I
did.
know, there's nothing pending yet because.
I don't think he had a second.
Do you have any motion?
Because we ruled on the motion to dismiss for lack of personal knowledge.
So the motion that Mr. Norman made was withdrawn, which means a new motion is in order. And I would make that new motion, and I would make the motion to limit the hearing to items contained in the complaint.
Is there a second?
I just want to clarify because I think there are actually two complaints. Am I correct?
There are two complaints
That have been consolidated.
consolidated into one document, more or less, yes.
If that is the motion for those, as Mr. Bromer's put it, but to both those complaints as consolidated, I would second the motion.
Roll call, please, Mr. Executive Director.
Thank you. Ms. Cunningham?
No,
Ms. Tavares?
No.
Ms. Kaufman?
No.
Mr. Norman?
Yes.
Mr. Bromer?
Yes.
Chair Beatty?
Yes.
Vice Chair Beatty? That motion does not pass. It is tied 3-3.
3-3.
So it remains outstanding. Move on. It has not been approved, so therefore,
is it denied then?
historically, that is what the commission has done, yes. As there was no action to go forward, the commission has essentially denied the motion administratively.
Before we proceed, could we have a 5-minute break? I'm requesting a 5-minute break.
Make it 7.
7.
Well, the nice thing I know is
Well, I have a question. I'm not working out for it. I know how it works when I try that. There's no real opportunity. Somebody say, hey, listen, we got everything we needed. Any comments? No, what's approved? So that, so there's one.
That's what I figured.
But there was so much moving to set up and get things ready, and I didn't get a chance to talk to you before.
That's okay. I was running behind anyway, too. I got here at like 7:00.
Trying to adjust.
So I just wanted to kind of.
Yeah.
No, but it's good, you know, it's,
Yeah.
I gave you a copy of the piece on the page which has the
Okay.
names of all the parties.
Thank you.
No, I just wondered.
I'll see you.
Sure.
Yeah. I got it.
Let's say if you need another one, you know, I think we're good. There's one right here as well.
Right.
Okay.
Right. I would, you know.
Battery low, or are you paranoid?
Uh,
My battery's fine, but I get paranoid that it's suddenly gonna go zero when it goes so.
I don't know. That way it's clear, but I don't see that.
Okay.
Oh, I know. I really would be guessing as to what the evidence is.
Everybody got good.
I have no idea, I mean, it's a huge time, but I can't guess what theory's gonna come up with next. I mean, I don't, whether the motion passed, I don't think it passed. I don't understand what people really thinks.
Just so you're being reported.
I don't know what, I'll like to open it further. You're welcome to rail it.
No, I rarely do. I appreciate you doing this.
Broad shoulders.
Who's off in January?
Yeah, you're like sitting out there going, what the hell's happening?
Who's off in January? You?
Dennis and Catherine.
Oh.
Hey Chris, how you doing?
Phil, how are you, man?
Hanging in there.
Came back on or something.
Yeah.
I thought she was longer, right?
Well, I'm the one who miss you all.
You're ready, right?
No, it is September, so I'll send you a book on civil procedure.
Thank you.
And,
Will I be tested
I'll send you a book on civil procedure.
twice a month?
Because
I'm still learning it.
Yeah.
I'm gonna be declining the chair, and so it's gonna go to you.
Oh, no, it's not. No, it's not.
Oh, I think you'll be fat. Listen, wait a minute. How can you not say that? All the leadership that comes out of Allen County now.
There's a lot of you.
Yeah.
And
All the leadership that comes out of Allen County.
listen,
That's your county, right?
this is me. This is me, okay? Actually, I live in Always County.
Oh, okay, I'm
Yeah.
sorry. I haven't taken Ohio geography and counties since
And we're close.
seventh grade.
Close, yeah, we're kissing cousins.
That's right.
Yeah.
So Lima, is Lima in Auglaize or Allen?
Allen, yeah.
Okay, all right, I'll make sure I'm not on
Yeah.
that one.
No, and actually,
Or just too
Do
long.
I still have a minute to run down and get a bottle of water?
Go ahead.
gotta be quick, run. No, I'm just kidding.
I just hope the credit
We're not gonna be talking that much when we get back here, so I hope that's not for that purpose.
Is that more motions?
Yeah, no, Lima is in Allen County.
No, it's not, it's cheap. It's $60, but it works pretty good. But,
You told me to cut them right
I told him that would off.
Yes, it did.
What?
We talked about it. Yes, I don't control myself, I'm the attorney general, not a baby, it's two of us that were definitely captain.
But that sits here, I guess.
But I'm like you, my spouse is an attorney, so, you know, it's like, but it.
We'll have you serve with the
I would say, yeah, absolutely. I'm happy to not.
Okay, thank you.
What do you think about things from a different perspective?
But I think there is some, but I do love the insight we get though. Amy, Otto and Catherine.
Not me.
I'm sorry, I don't appreciate your insight.
I've been retired.
It's interesting, my wife is an attorney as well.
And it shows.
She does business stuff, she has never seen a type of Photoshop at all. She just constantly sees documents.
Yeah, that's crazy.
Oh. Okay.
Well, my husband does new criminal, you know, so it's like, he does a lot of workers' comp and personal injury and that kind of stuff, so that's a whole nother.
Did you have a piece number by any chance?
I did.
Not. I apologize, usually they give us a white one, and I have it, it's like a cheat, it's not, this morning for whatever reason.
And you know, I kind of was thrown a little bit because of the election commission sign and all the paperwork that at the commission, that just threw me off as far as the meeting. So, just.
As soon as, yeah, no, as soon as those are done, they're, it looks like easier.
And this is where we were.
Whatever,
They just-
I'll be here.
All
All right, thank you.
witnesses on the other side, they bring the witnesses up, almost identical. Experience, almost deja vu.
My dad did the opposite side, he had human resources for One National, and his father was the president of the last one growing up to my grandfather, his father was.
Oh, awesome, thank you so much.
They were over in Illinois. So I took tests. My dad was on one side of the fence, and my grandfather was on the opposite side of the fence.
Hey, but you learned it from both.
That's why I'm right here in the middle.
I do, yes.
Okay. And, so,
Often have phone cases. Once in a while, they'll have small thunderstorms. And the civil rules don't apply there. So it's kind of a free for all. I always ask my clients, hey, let me do this court, you have to follow the civil rules, the judge can't do it backwards. Let them do it that they want.
Mr. Richter, what's the next one?
So when are you?
The.
Agreement motion quash.
More sympathetic.
You should.
I apologize, I did.
If you need a search format, we can.
Right.
Got what you need, that's it. Okay.
I set them all up pretty much as far as formatting. I agree with you that it just seems like.
Yeah.
That someone can, doing it all the rest of the year.
So we're-
You don't know what you don't know.
I can still send you one, just that way you've got it and see.
Doesn't like each other. Yeah. I mean, you're welcome.
Greatly reduced from what it was.
Yeah.
Yeah, you know, hey, mom, will you go over this because you always, you always keep the books or whatever at, yeah, and stuff.
I just had a trial with them, you know, so
Yeah.
I just tried to have.
Totally.
At this
No one
point,
was bored
just
about
do it on your computer,
When I
you know,
first
I mean, you have to take a test at the end so that they know that you actually, you know, went through the process. Yeah, I mean, this is extensive, it could be a 30-minute, you know, how-to, and then, you know, everyone has to do it.
I'll shift over to see you guys.
No,
I mean, it's, you know, some things are
right.
ours a little middle. The only one you really see it is
That's good.
Yeah. Oh, absolutely. Yeah. She's got a first grader and she's got a senior.
So that one.
When I went to get my water, it was like that.
Talk about aggravation, I'm like, if that isn't enough to make it, you know. Oh, I'm so glad. She really loved it, so. I mean, for her, yeah, so I asked her to go and talk to her about it. I never, really good, I was like, listen, I wanted to see you, I don't, you're not laughing. Like, I don't have to excuse myself, she's a pretty, she's on the ball, like, she is a researcher and. Like, dotted her eyes across her TUS.
Chris, can you, look out in the hall and see if, Commissioner Cunningham's out there?
She was down by the drink machine, in the hallway down.
Okay, thank you.
Yeah. I know, I was, when you get a call, you don't know, and they say, oh, is this Natasha? You're never supposed to say yes. Because that way they, like, because then
A
there's.
good number, yeah, they know the name.
And then they can like.
Give them a first look up.
Exactly. The little scammers would put their addresses in something for a while.
They make money.
Right.
She's on a phone call.
That's smart though.
I had to construct and keep that case where he was asked to the parties to deposit $1,850. There's 12 parties, which is like $22,000. I'm like, I had the same reaction, I'm like, what?
Oh, you know, your grandson.
For what?
His name is, you know.
His preparation time to mediating,
He was on spring break.
pre-mediation
All
discussions.
of that, but they sent money.
Private.
He said, my mom sent $1,500. And she's
All my wife said she was
But, you know, when you first have kids into it,
He said
you
that's not front
know,
pocket.
and they kids or whatever.
I told him, I said, as we get closer,
Those are the
I
easiest
see
to
you
take
peer
your
around.
down straight track down there. Yeah.
Well, I work for an insurance company. A lot of the guys who do,
There's multiple,
they
right?
get
Yeah, they'll come in
as they're getting ready to ride off into the sunset, a lot of them come in here.
I think my husband and I watched one of those. He's like,
Probably
he's all of
okay,
a
but the
sudden.
insurance company, they don't have to control their pockets.
We're watching YouTube TV like it's on us. It's driving me crazy.
Not a lot of stress.
He's been so, I think saddened and enthralled with the Gabby Petito. And so he's watched everything and he, you know, it's funny because, we were placing food in one. So, you know, the Lonnie boys from but I said, listen, in our budget, I listened to all the conversations from the beach. I said, $10 is on there. And then there was a, did you see that? I do believe that's him. It's in the basement. Sorry, right?
No, I'm sorry, I missed that.
Like Destin, and Preston, and Macon. So it's kind of like they were talking about Lower Alabama, you know, because it's right there. The border. Is there what it is about that?
Okay, let's get started and go back on the record. And so the next is the Pam Freeman motion to quash.
Mr. Chairman, members of the commission, before we proceed to that, I would like some clarification as to the 3-3 vote. I understand you denied the motion to limit. The question I have is whether that means it is still limited by virtue of our constitutional rights to have the facts set forth, as Mr. Norman pointed out, or whether at least 3 members of the commission believe that it will be appropriate for Mr. Hicks to present evidence and for my client to be potentially criminally liable for failing to report expenses that were never identified in either of the complaints. I think that it's plain. I think, well, obviously I agree with Mr. Norman and others that the face of the complaint is limited to saying you failed to report an expense, and this is the expense that you failed to report. Obviously, there are other matters about this expense that you failed to report, but the Constitution, you cannot, and statutorily you are prohibited from allowing a hearing in which other expenses that were never identified in any of the pleadings are then putting my client in a potential criminal jeopardy without any adequate opportunity to prepare for that. I understand the commission's concern, well, this will take too long, there might be other complaints, we might be back in the same place. That is not a justification for denying my client his right to have in writing what it is that he is alleged not to have properly reported. And just because you cite a statute doesn't mean that you are liable to defend every possible way in which maybe you failed to report something else. And I would respectfully suggest that there be some clarification as to whether or not we at least have our constitutional rights based upon pleadings, or whether in fact 3 members of the commission believe that any facts that were never pled, that he can argue at the hearing as a basis to maybe have my client referred for criminal prosecution are going to come on in. Because we do have some real interest in knowing what the heck we're going to be trying to defend in 2 weeks.
All I can tell you is there was a motion, it wasn't granted, and if I were in your shoes, I would be prepared to object at the hearing. I don't know what else I can say.
I think your objection today is noted as well. That you bring up. It's been preserved.
I would request if there's any of the minority, or excuse me, any of the folks that voted against that are so inclined that there be a motion to reconsider.
No.
There being none.
All right, let's proceed. On motion to quash.
Mr. Chairman, members of the commission, I'm also here on behalf of Pam Freeman, the wife of Alan Freeman, who has been subpoenaed to testify not about either of any of the items specified in the complaint, but about a direct male spouse chase piece, according to Mr. Hicks' June 25, 2021 email. It's not about 6 invoices that are in the first complaint. It has nothing to do with Luke household in the second complaint. So even in terms of relevancy, it should be excluded under Evidence Rule 402 and the right of this commission under its rules 3517-1-11B4C to exclude irrelevant evidence. Moreover, even if she were being subpoenaed to give relevant evidence, she can't, as the spouse, be required to testify against her husband when he's being charged with a crime, which he potentially is in terms of that they've accused him of doing something that they're going to seek a criminal referral on. And that's Ohio Evidence Rule 601C, as well as Revised Code 2317.02D, gives spouses rights, absent consent or waiver, and she's not consenting and she's not waiving her spousal privilege, not to have to testify against their spouse. Mr. Hicks has subpoenaed her for irrelevant testimony and to testify against her husband, which is improper, and therefore it is overly burdensome and frankly solely for the purpose of harassment and shouldn't be issued under the commission's own rules. But in any event, so it's the only purpose for which she is subpoenaed, are purposes for which she has a right not to testify. We believe that the motion to quash should be granted.
Okay.
Yes, it is, with the same limit, yes.
So no questions, right? So it's clear that Pam Freeman had communications with Megan Fitzmartin, was transferring imagery that was used in various matters with Megan Fitzmartin. Megan Fitzmartin was the person involved with the approval of media pieces. That's also in the discovery. I wish to question Pam Freeman on her communications with Megan Fitzmartin to the degree that implicates her husband or something. I would assume she could assert her right against self-incrimination or her spousal privilege. But it's clear, and I provided in my response, that the wife of Alan Freeman was having direct contact with Megan Fitzmartin, which is a key figure, and transferring media pieces to Megan Fitzmartin for use in Alan Freeman campaign materials. And I think it's fair game to ask her about those communications with Megan Fitzmartin. I'm not planning to ask her about any communications whatsoever with her spouse, Alan Freeman.
I think I reserved some of my 5 minutes. Nothing in the rules require that it be communications with your spouse.
Don't you have to say you're reserving time? If we're going to follow the rules, you have to declare you're reserving time up front.
We're gonna give leeway on this, move forward. Thank you.
None of the rules say that it's, the rule against requiring a spouse to testify against the other spouse isn't limited to communications with that spouse. In the Evidence Rule 601. There is also a separate, privilege against communications regarding the testimony communications. So there are separate requirements. She has a right not to testify at all against her husband, and obviously if she's not testifying against her husband, it's not relevant, and that Mr. Hicks wouldn't have any reason to call it.
Any discussion? Questions for the? Questions? Discussion? Yes. I'd like to hear from the executive director.
I look at it as, the spousal privilege here, and that's why I recommend sustaining the motion. I think it's regardless of the elements of why the testimony is being sought. I think a spouse has an ability to not testify when it involves her husband. That's where I'm coming from.
I move that we grant the motion to quash.
Second.
Roll call.
Catching up writing, sorry.
Commissioner Tavard,
No.
Commissioner Coleman,
Yes.
Commissioner Burrow,
Yes.
Commissioner Norman,
Yes.
Commissioner Duncan,
Yes.
and yes.
Thank you. Sorry, I was slow reading my writing. Okay, so,
Count, please.
oh, I'm sorry, that would help. That motion passed 6-1.
5-1. That was
5-1. I know you're right.
That's set, man.
We're not going to.
Just when I got it right the last time, I blew it on that one. The next motion up for consideration would be the motion from Jane Timken, who is moving to quash the subpoena that has been issued to her.
Okay, do we need to go out and get,
No.
oh, that's the name.
Oh.
Good afternoon.
Good afternoon.
Introduce yourself, please.
I'm sorry.
Can you introduce yourself, please? Good
Yes.
afternoon.
Absolutely. I'm Anne Marie Stara with Record After, and I'm here on behalf of Jane Timpton along with the clients. Before I get started
And
on
I'm
the...
sorry, the
Yes.
ladies next to you, which person?
Rachel Mays.
Okay, thank you.
Before I get started on the motion, would I be able to reserve any of my 5 minutes that I don't utilize during the presentation? As
You're a
rebuttal?
good listener,
Thank you very much.
How much would you like to reserve?
Well, anything that I could use during my 5 minutes.
Or to have a legally he grants it.
I would, that I would appreciate as well, so thank you. So as I indicated, we are here on behalf of non-party Jane Timken, who was served with a subpoena to appear on October 7th at the request of Mr. Hicks. We filed a motion to quash, which I know you've already read, and if you have, you saw that we filed it because Ms. Timken has no personal knowledge of the matters set forth in either of Mr. Hicks' affidavits. She doesn't know anything about Mr. Freeman's media buys or anything about Luke Householder's activities. Ms. Timken also has no personal knowledge of the alleged violations of campaign finance law that Mr. Hicks accuses Mr. Freeman of committing, and those are at the heart of the matter before the commission. Ms. Timken also has no personal knowledge of the day-to-day field operations of junior campaign staffers, such as Mr. Mancini, who is referenced in a parenthetical in one of the complaints filed by Mr. Hicks. In short, Ms. Timken, who is chair of the Ohio Republican Party, has responsibilities at that time that were outward-facing. Someone else, the executive director of the Ohio Republican Party, was responsible for the day-to-day field operations. So if you've read our motion, you've also seen that we moved to quash because during a conversation with Mr. Hicks, he indicated that he was also going to subpoena Rob Sekar, the former executive director of the Ohio Republican Party, as a witness on October 7th. And since Mr. Sekar does have personal knowledge of the matters that I just referenced, it was indicated that if you are subpoenaing Mr. Sekar, then why do you still need Jane Timken to come in and answer the same questions which would be duplicative? And Mr. Hicks would not respond as to why he needed Ms. Timken if he was bringing Mr. Sekar. Again, Ms. Timken has no personal knowledge of those matters, and Mr. Sekar does and is available to testify on October 7th. I also wanted to reference a couple of things that were in response to the motion to quash. One of them was Mr. Hicks cites to a radio interview that Ms. Timken had in Claremont County, and he tried to draw the connection that because she had a radio interview in Claremont County, she seems to know everything about Mr. Freeman's activities and his campaign, and that's just not the case. What she did in that radio interview is something that the chair of the party typically does. That's an outward-facing activity. She came in at the invitation. She spoke regarding a different candidate during that presentation or that interview. And that does not mean that she has personal knowledge of what was going on with Mr. Freeman's campaign, all of the people working on it, who was supervising Mr. Mancini, or any knowledge of Luke Householder. Because Mr. Hicks was unable to determine or identify for us what he needed in an affidavit when we had proposed an affidavit for Jane Timken rather than her coming in to testify before we knew he was going to call Rob Sekar, it seemed that there's no real valid reason for her to come in other than he wants her to come in to harass her, that the purpose of the subpoena is harassment, particularly knowing that someone else can testify to the things he's identified and she cannot and does not have personal knowledge. If he really wants testimony that goes to the heart of what he believes his allegations are, then we ask that the motion to quash Jane Timken's subpoena be granted and reserve any time that I may have.
Got a little over a minute.
All right, so I want to reserve time like she did, if necessary. So Jane Timken, the reason why I subpoenaed Jane Timken is because this case involves specifically how resources in the ORP and how resources that should probably be in-kind contribution to the ORP that were involved here, how they should be reported vis-a-vis this candidate, Alan Freeman. So there were resources from Constant Content supervising the ORP resources that all come into play here. Luke Householder, Tommy Rolfe, R.J. Mancini. They're all interconnected. Now, she just represented that the chair of the Republican Party had no idea who was, I guess, I don't want to exaggerate. He has no personal knowledge of what the management structure was of ORP resources or how resources that were not being reported on any finance reports the existence of them. And I guess what she's saying is Rob Sekar does have knowledge of that, and, but the chair of the party did not have knowledge of that. I would like to have her, Ms. Timken, make those assertions. This is the first time somebody laid out, and in the call I videoed, they went and answered the question, what is she prepared to represent? Okay, I was approached about her potentially having an affidavit in this case. I would be glad to see an affidavit from Jane Timken stating that she didn't have any personal knowledge, and that would help to clear up the issues, but I don't know that just, I think it probably should go beyond. That's what the original intent of the call was. So I believe that I want to make sure that the assertions that Jane Timken doesn't know how those should have been reported, because remember, part of the resources were reported by the ORP and should have probably been accounted as an in-kind, I think, by Alan Freeman. But what I'm hearing is she had no personal knowledge of that, but she should have personal knowledge of what's the policy and what was supposed to happen in these cases and where were these resources supposed to be reported, and was there information given to candidates to facilitate the reporting? Because what I understand is that the ORP, I'm getting a little ahead of my headlights, the ORP provides information to the candidates for being able to properly report their in-kind contributions. Those are all germane. I think it gets down ultimately to what should have been reported on Alan Freeman's campaign finance report vis-a-vis Lou Costholder, R.J. Mancini, and the supervisory resources that were involved. But I would have loved to have Ms. Timken actually put most of what you just said in an affidavit, and if she would be prepared to put that in a signed sworn affidavit, what you just said, I would be fine with the motion that being quashed. But otherwise, I think I want to be able to have her make clear those things as to these resources and where they were reported, and what was the policy of the ORP in terms of where they were reported, and what does she think, per the policy of the ORP, should have been being reported by the candidate. But I would love to have an affidavit that says that, and then I'd be glad to go along with the quash. Am I out of my time?
Yes.
I'm done.
Well, by my watch, yes, but.
You're a smart guy, jump right on it.
No, but I think the way we'll have the response, and then at that time, let us get into if there's any commissioners that have any questions regarding that. Normally, this type of proceeding, the person that brings the motion, and then the response, and then the rebuttal, and that's really it.
Okay.
Okay, go ahead.
I would just indicate that Mr. Hicks suggested that Ms. Timken has no knowledge of the management structure. That's not what we're saying here today. What we're saying is that she did not have day-to-day knowledge of the people who are on the ORP staff as junior campaign staffers. I should say on the ORP payroll as junior campaign staffers, and how they were deployed at any given time. That is not something that she was responsible for. There were other people who handled that, and Mr. Seacard does have personal knowledge of that. So I just wanted to clarify that is what I was trying to say. Not that she doesn't have any knowledge whatsoever, but regarding what he's asking here for these specific, only two people have been mentioned, two specific junior campaign staffers. She was not involved in the day-to-day field operations and does not have knowledge of that. Also, one of these people, who householder per his allegations, was paid for JP and Al Associates, which again, that's something that Ms. Timken does not have knowledge of. That's probably should be addressed to JP and Al. And Ms. Timken doesn't know what Mr. Freeman did or did not actually report, but as Mr. Hicks indicated, the ORP did make their appropriate disclosures, and those are in the public record as to how those resources were made in kind to the HRCC. Thank you.
Do I have any time for anything like that?
Let's let the commissioners ask some questions right now. If commissioners have any questions regarding this or comments.
Well, my comment would be is he was asking for an affidavit, but he's had counsel stand up here and make representations on behalf of her client. It seems to me that when we've got enough information for this counsel, I would move that we quash the subpoena.
I have a question regarding the policy of the ORP and in-kind, since that seems to be where Mr. Hicks has some concerns about how in-kind services by the ORP is recorded, or what that policy is, so that the campaign or the executive director or the junior staff members know how it's supposed to be monitored on behalf of the ORP. Does she have that kind of knowledge?
So I can't speak to a policy because I don't know exactly what policy anybody's referring to. I can tell you that Mr. Secar can speak to the practices of the people that are on the payroll, and then their salaries are made as an in-kind contribution to HRCC.
And I'm sorry, what is the status of Mr. Secar being deposed or submitting affidavit or anything like that? I'm assuming you don't represent him, but I am opening up the door to Mr. Hicks because I'm sure he knows the answer.
So I can't respond. We will be representing Mr. Secar. It's my understanding that a subpoena has been issued, but I don't know that it's been served. That I don't know, but I believe that it has been
It
issued.
should be served through you if you're the one representing him.
Well, I believe he's prepared to be here, but as far as I know, as of yesterday, he had not been served with a subpoena.
And I'll quickly interject, I have prepared the subpoena, I have sent it to the sheriff's office, we have not gotten back, at this point at least, confirmation that there has been service. But there has been a subpoena prepared and circulated.
And Mr. Hicks, have you had any other opportunity for discovery on this particular individual other than this?
No. I would like to just very quickly say two things that she said. She said there were two campaign staffers, which would be R.J. Mancini and Luke Householder. R.J. Mancini was reported by the ORP, but not reported as an in-kind. Luke Householder was not reported anywhere. He wasn't reported by the ORP, he wasn't reported as an expense to Freeman. I think she's raising the points that are the relevant questions for Ms. Timken about where should these resources, per your view, in the policy of the ORP, have been reported. It gets at the point of should they have been on Alan Freeman's expense report and how so or not. The other thing she said was that Rob Secor is aware of the practices. He's not aware of the policy. That's what she just said. So, and my questions for Ms. Timken relate to what's the policy. I wouldn't expect a junior person like Rob Secor to be an expert in campaign finance and where by policy these resources should be reported on finance reports. I would expect the party chair, Jane Timken, to know those answers. That's why she needs to be asked questions specific to where should these resources have been reported because they weren't, one of them was reported by the ORP, but not as an in-kind by Freeman. One of them wasn't reported by anybody.
Okay, thank you.
I like the way you cut me off. I'm even positive, good.
So, Mr. Hicks, it's your assumption, and I use that word, your assumption, that because Ms. Timken is chair, or is chair of the Republican Party in Ohio, that she must know all this information you're seeking. You have no other basis other than your assumption. Is that a fair statement?
I think I would, that I believe that the chair of the party is responsible for the policies of the party. So yes, not only do I expect her to know that, I expect her to be the one that's creating those policies and enforcing those policies, whether they be written or unwritten. And that's why it's so important to be able to question her on what was the policy. Where should these people have been reported? And we get at the point, maybe Alan Freeman shouldn't have reported. Maybe he did the right thing by not reporting anything. Maybe Luke Householder didn't need to be reported by either Alan Freeman or the ORP. But as the chair of the party, she uniquely, unlike Mr. Secor, who might know practices and generally what they were doing, she would know, and only she would know, what was the policy, or she would represent that they didn't know. She didn't know what the policy was.
Okay, I think you answered my question. But, and for the record, I feel that before we take this vote, I have to disclose, and I just discussed this with our executive director, that for 15 years I represented all the union employees at the Timken Steel Company and the Timken Bearing Company. And in that time, during that time, her husband was the CEO of Timken. Now, I've never met Ms. Timken, and I don't feel that my eventual vote is in any way prejudiced by the fact that I represented the union during those years. But I wanted for the record to disclose that.
Thank you, so
There is a
Executive
motion.
Director.
There is a,
Any
what? Oh.
comment or recommendation or thoughts?
Yeah, just a comment before Phil shares his thoughts there. Just a question with respect to getting information on the policy of the ORP on in-kind contributions. Who else will we get it from, if not the chair? Is there someone else that we get it from? What the overall policy is of the party, not a staff member who's paid, but the leadership of the organization. Just like for the Democrat Party, there's a leadership team, and, you know, they're the ones that discuss, develop bylaws and policies, etc. So who else would we get that information from?
Council, that's a fair question if the crux of your argument is that the chairwoman would not have that information, then I assume the next logical step is this is who has this scope of information.
And I'm not here to testify.
I
So I
understand.
just want to make it clear that we are talking about a policy sort of in the abstract, okay? And I don't want to represent that I know what policy you are all referring to necessarily. But I believe that Rob Secar, if there is a policy that has been approved by the leadership of the organization, he was the executive director of the organization and responsible for implementing that policy, that he will be able to testify about that policy. And that's why I called it a practice versus a policy, because I don't know that there is a written policy, and that's what I thought perhaps we were talking about. But I'm just not here prepared to say that the policy you're referring to is X, Y, Z, and here's what it says. But Rob Secar, as the executive director responsible for the day-to-day field operations, would understand what you're referring to and would be able to testify
Well,
to that.
is it an issue of, and maybe I misunderstood your initial presentation, that you're saying that Ms. Timken affirmatively does not know, or you don't know what Mr. Hicks is talking about, so you can't say if she knows or doesn't know?
That's correct. And in addition to that,
The
even
correct
if
is the
she were to
latter-
know any
the
part
latter.
of that, Rob Secar also knows it, and he knows these other things about the day-to-day field operations, which seems to be, at least it was my understanding, based on not only the conversation with him, but the reasons that he asked for the subpoena and what's his complaint, that what he was looking for was the understanding about those junior staff members.
Yeah.
Does that answer your question, Commissioner, or does that lead to more questions?
It probably leads to more questions, just knowing, having run campaigns and being part of a campaign. I know when in-kind contributions come into my campaign. And I know that the party makes a decision of who they're going to provide in-kind services to. And that is documented. The party knows what their policies and practices are. So I guess, I don't know whether it's Secor, I don't know whether it's Timken, but certainly the leadership has documents on how they do X, Y, and Z.
Okay. Any other comments or questions? Well,
I guess just one question, Mr. Co-Chair, or I should direct it to Phil. We do have a subpoena for Mr. Secor
Yes,
outstanding.
it has been prepared and circulated.
Okay.
You know, right now, I don't know status of service and have not checked back with me. I mean, we could request, or we could ask his counsel, who has identified himself as counsel, if they can guarantee that he will appear, since you're here with us now at this point.
It's my understanding he's planning to be here.
Hasn't Madam Secretary to accept service on his behalf?
I'm going to accept service on his behalf.
And to clarify, because you, Mr. Hicks, have referred to junior campaign staff, but Mr. Secar is the executive director.
He is not a junior
the
campaign
junior
staff.
campaign staff. So he would have all the knowledge that we are trying to, make known.
Yeah, I'm sorry to interrupt, but he is not a junior campaign
No,
staff.
I just-
Absolutely, you are
yeah,
correct.
So I've just heard that term bantered, and I just want to make sure that we are all clear that he is the executive director and that he has,
He is the former executive director.
Okay.
We should just clarify that, but he was the executive director at the time.
So-
he has all the knowledge that we are trying to bring.
So I want to clarify what I said. I said a junior person, when I referred to him. The junior campaign staffers are Luke Householder and RJ Mancini, and I want to point out something that's very important that's come out here, is that remember, Luke Householder, who's directly in the complaint, was not shown anywhere, And based on Mr. Secor's statements, there could be a difference in what was the actual policy and what was actually happening in the field. Because Secor, RJ Mancini was an ORP staffer and reported by the ORP the questions about the in-kind. Luke Householder was being supervised but wasn't being reported anywhere by anybody. And one of the things behind this is, behind that particular line of questioning, where only the chair would know the actual policy, because potentially there was a breakdown in the field of what was actually happening versus what was the actual policy. The policy is important, most important, because that would reflect on where should these resources have been reported on a campaign finance report, and to what degree should they have been reported on Alan Freeman's campaign finance report. And I don't think anybody other than Jane Timken, or if you can name another person, from a policy standpoint, could reflect on what was the actual policy of the ORP.
I renew my motion to quash.
Second.
Call the roll. Executive Director, any more comment?
I can call the roll this time.
Comment on the motion?
After hearing the arguments, I'd sustain the motion to quash, particularly since it's been represented that Mr. Secar will be present, and will be able to testify on all the elements that have been raised here in terms of policy elements, et cetera. And so I would be inclined to grant the motion to quash. Mr. Brown,
Yes.
Ms. Kaufman,
Yes.
Ms. Tavares,
Yes.
Mr. Norman,
Yes.
Ms. Cunningham,
Yes.
Mr. Beatty.
Yes.
That motion passes 6 to nothing.
Counsel, I know you said you accept service. Have you received a copy of the subpoena, or do you need it?
I have not received a copy of this.
Chris, I think you've got information because they filed a motion. Can you forward that to her, please?
I can do that.
Thank
Thank
you.
you, Chris.
Absolutely.
Thank you.
Last item at this point, Mr. Vice Chair, members of the commission, and there is a motion to quash concerning Jean Schmidt and her presence at the hearing. And Mr. O'Brien is presented us with that motion.
You may proceed.
Thank you, Vice Chair Beatty. The complaint that was filed against Alan Freeman is in many respects similar, if not identical, to the complaint that was filed against Jean Schmidt. Jean Schmidt is probably in parlance and at least in argument presented by Mr. Hicks previously and even here today, a co-defendant of receiving in-kind contributions from a high Republican Party that were not reported, and also receiving the same media production company and media buying company involved in at least a proffer that Mr. Hicks made to Mr. Richter when the scope of these hearings were being scheduled. It related to her knowledge or participation in filming of ads for both Mr. Freeman and Mr. Schmidt, as well as both of them purportedly receiving the benefit of Luke Householder, having been down there and allegedly working on both their campaigns. Quite clearly, he can't issue a subpoena for her in the hearing on October 7th and have her testify. She's functionally, as I say, a co-defendant. She's functionally charged with the same thing, failed to report and the in-kind as well as other, what are alleged to be corporate contributions, which to date were not quite clear who the corporation is. But in any event, I think it's absolutely clear that under no circumstances can you subpoena her and have her testify and appear at the hearing for Mr. Freeman. And at least I would really have nothing additional to add. I think she's quite clearly in a different situation than, for example, Ms. Timken on the previous case, who is a witness. She is a defendant, functional defendant in a quasi-criminal proceeding, which the commission has the ability at the end of the day to refer for criminal prosecution. So there's no way that she can be subpoenaed. If you have two people charged with armed robbery, as an example, and they have separate trials, separate dates, you can't subpoena the other person who's charged along with the two people that robbed the store to testify at the first hearing. I think Mr. Hicks kind of takes a position, yes I can force them to take a witness stand, yes I can start asking them questions, and if they want to take the Fifth Amendment, they can do that. Well, that ain't how it works. You just can't compel their attendance, you can't compel them to take the witness chair, and you can't even ask that first question without their consent. So having said that, I'm happy to answer any questions any members of the commission have.
Any comments, questions?
Okay, thank you for your attention.
Mr. Hicks?
So the specific subject matter that I wish to question Gene Schmidt over is the actual filming of the commercials, where she was present, other candidates were present. They were actually filmed at locations that were her family locations and relatives of hers. Also, the invoices in the original affidavit, several of them were joint invoices. So between her campaign and Alan Freeman's campaign. So I think I have the right to I didn't make allegations in her complaint about the filming of commercials, some of these specific invoices. And I think I have the right to verify, use her as a witness to confirm that she was present, Freeman was present, who was present at these filmings that took place of these commercials. Megan Fitzmartin was present. The locations of those commercials. And then the invoices, that she acknowledged that the invoices, which ostensibly she has, based on her campaign finance filing, that those joint invoices were invoices that tied to her partly to her campaign. So I think there's a set of information that only she has, that only she can confirm, that, for example, if I play a commercial, were you present at the filming of this commercial, was Alan Freeman present, that sort of thing, that only she can do. She's inextricably tied to this because there's certain facts of the case I would make against Alan Freeman where she was directly present at when those things took place. So I think a motion should be denied, and I'm glad to limit my questioning of her to just the facts of who was present at the filming of these commercials, were these invoices that were in his, did you pay these, did you acknowledge these as valid invoices or not within your campaign? I don't think those particular questions have criminal culpability on the part of Gene Schmidt, but they're instrumental to the verification of the facts of this case.
Any more questions? Mr. O'Brien, do you have a response, or you fine for that?
I really don't. I think the issue is very clear and would ask the commission to quash the subpoena for her for the Freeman hearing.
Would she be willing to have an affidavit confirming that these were filmed at her locations or anything like that?
No, that's out
I'm sorry.
of order here. Any further comments, questions? Okay, is there a motion?
Move to grant motion to quash.
Is there a second?
Second.
Call the roll.
Before we vote, I'd just like to hear from the legal perspective here, from our sitting attorneys here, and from the executive director, Mr. O'Brien proffered that it's illegal. It would be illegal to have her come in and testify since she is a co-defendant.
Functional co-defendant, correct?
You can't force her. Once you open the door, she can't close the door. Once she starts testifying, all bets are off and they get to ask whatever questions they want. And so they have the right to say, I'm not going to testify.
There's a complaint pending against her here, which we heard and over great debate about whether or not we were going to dismiss it or not, so it remains pending. And so it's not just necessarily what's in that complaint, but as we've talked about a lot today, if she testifies and evidence comes up that is sufficient to maybe instigate the filing of another complaint, not necessarily one pending before her, that would also be barred, which is why people have a constitutional right against self-incrimination. So you can say that's legal or not, illegal or not legal, but I view it as sort of a constitutional right. So when she has been charged in a quasi-criminal proceeding, in one case, I don't think that you can force her to be a witness in another case, in which she may incriminate herself in the pending case, but also for the filing of possible other criminal proceedings against her. So that's sort of, it's not really about the intent of, how you're gonna box that testimony. It's really about her constitutional right, from my perspective.
You don't need to hear more from me, they said it all. Okay.
Well, and I have a question though. So Commissioner Norman said, once they're there, even if someone says, I'm not going to ask them that, if they do, it's, no holds barred.
Once you consent to testify, you can't pull it back.
Right. Yep, thank you.
Code? Ms. Kaufman?
State the motion.
Motion to quash.
Motion to quash, to grant the motion to quash.
Yes.
Mr. Brommer?
Yes.
Ms. Tavares?
Yes.
Mr. Norman?
Yes.
Ms. Cunningham?
Yes.
Vice Chair Beatty?
Yes.
I almost changed your name, sorry. That motion passes 6-0.
If you can become a lady.
Yeah, what?
He's Irish.
I think you can call me O'Brien.
Yeah.
Thank you, members of the commission.
Can I ask one thing about the status of other subpoenas? Because I'm concerned with October 7th that some of the subpoenas haven't been served.
It's out of the commission. You can, but it's out of the commission.
I can check on them either
Well,
later
some of the
today or
people have
tomorrow.
already agreed to receive email service, like Adam Bird already agreed, so why isn't he even getting email service when he's told you all
I
that?
didn't know that anybody else had agreed to email service.
They'd
That
have
was
to-
never presented.
Specifically, Adam Bird got email service before.
I would respectfully suggest that this is not on the agenda.
RJ Mancini did, I never served that.
And it can be communicated directly with staff council without him.
Well, I'm just concerned that there's a lot of witnesses on this list that's going to impair my ability to put a case on, when for reasons I can't explain, there was significant delays in the subpoenas even getting issued to people.
Well, I would say that that's not an issue that's currently on our agenda. I suppose you need to work through the executive director if you've got an issue.
Those are procedural issues that go
It's
to
a
the
fairness
executive
issue.
director.